Good morning, and may it please the court. For the reasons that follow, the trial court certification order should be affirmed. First of all, I want to clarify, this is not a garden variety PIP case. There are federal statutes in play, and as this court is well aware, Judge Salter, in the Real case, you set the platform for what exactly the law would be that controls this particular case.
Judges Shepard and Judge Rothenberg set the pattern.
So here's how this works, because I think that appellant raises issues really that are not part of this case. No one is saying that just because there's demonstrated responsibility, there's a responsibility by the PIP carrier to automatically pay. MSP versus Allstate establishes that once there is an insurance policy that a no-fault carrier provides coverage at the same time that a Medicare Advantage organization provides Medicare under Part C, or original Medicare provides coverage, that is sufficient to meet the threshold to file a Medicare secondary payer claim.
I think where we're having the issue may be, at least one point that concerns me, which is that secondary payer status is really intended to be a penalty. Okay, 200% of the claim, as in Western Heritage. So the concern is, if that's a penalty, isn't there a process to first say, hey, you owe me this?
Yes.
And doesn't that have to be done and shown to have been done and in every single case? And isn't that more amenable to a case-by-case determination? Assuming rational action by the PIP carriers.
So the direct answer is no, and here's the reason why. As Judge Luck properly announced the elements of the cause of action under Humana versus Western Heritage, we must show that there's a primary payer. That's real simple to do. There's an insurance policy that provides insurance to the beneficiary, and there's an insurance policy, i.e. Medicare Advantage, that provides coverage to the same person. You have to prove that there is either failure to pay or failure to reimburse and damages. One of the biggest factual differences that exists in most of these no-fault cases is that when no-fault is triggered, generally they have not paid, meaning the no-fault carrier has not paid. These are all claims that have already been paid by Medicare. Medicare's system is way more stringent than a no-fault system in terms of how they pay. So these payments are controlled by federal law. Federal law does not allow or permit for payments to be made unless there's a relationship between the physical and mental condition of the patient. So the next question is, how are they supposed to know? Well, there's a system in place. It's called MSPA 111. The carriers are required by law to report when they have responsibility. It's called ongoing responsibility by part of the carrier. This company, as a practice and course of conduct, which is the evidence that was adduced at the certification hearing, has no system to report. In fact, we saw, I believe, 107 cases, and 104 of them were never reported. The reason why that becomes important is because under Baxter, which we cite in our brief, if the company has knowledge or constructive knowledge, that triggers Medicare payments and Medicare liens are automatic under Porter.
Counsel, if that was the law, if it was that there's payment by Medicare as a conditional payment, and therefore the PIP insurer who is covering the same person must pay because Medicare has already determined it, then why would the 11th Circuit and MSP Recovery have specifically stated that while these dual actions are going on, and I agree with you that it's all done together in a claim, yes, that you're allowed to bring this claim under the MSP Act, that there are significant defenses that can be brought. I think the way the court said it in the MSP Recovery case in the 11th Circuit was, quote, "This does not relieve plaintiffs of their burden to allege in their complaint and then subsequently prove with evidence that defendants' valid insurance contracts actually render defendants responsible for primary payment of expenses, and defendants may still assert any valid contract defense in arguing against their liability."
Yeah.
If that's the case, then how is it that payment alone by Medicare is sufficient to trigger required payment by the PIP insurer.
Payment by Medicare provides at a minimum constructive knowledge. We are not saying that just the fact
Constructive
that.
knowledge to the carrier?
Correct. So we're not saying that
I mean,
it
does the
automatically.
carrier get knowledge that Medicare paid it?
Yes, because the carrier is supposed to report when they have a Medicare beneficiary that they insure, and therefore they're supposed to report it to the government. So this is the reason why we also, and the evidence on top of that.
But wouldn't you have to prove initially that the carrier got some notice of the bill?
Well, the notice is the fact that a Medicare beneficiary is receiving Medicare payments and has been paid for medical services, items and services, and therefore by them reporting and understanding their portals that provide this information, Your Honor. So basically, when you go into the Medicare portal.
I'm missing that. So
Yes.
I'm missing this, so help me here. Let's say there's a provider, X-rays. They send, I mean, I don't, help me. They send a bill to Medicare.
Correct.
Let's assume for the sake of hypothetical, but I would like to hear more. Let's say they don't send it to the carrier. They don't
Correct.
send it to the no-fault carrier. They just send it to Medicare. First of all, I don't know if that's just that never happens.
It does.
Huh?
It does happen.
Okay, so then how's the carrier on notice?
Because the portal that Medicare has establishes when payments are made. So if the carrier properly reports to Medicare, they'll know
What does
that
the
there's.
carrier report? The carrier, I mean,
The carrier is supposed to report to CMS, Medicare,
what?
when they have a policy of insurance that insures the same Medicare beneficiary that Medicare provides benefits for.
You're positing an affirmative duty on the part of the PIP carrier to run out and look at all payments by, not Medicare, but by this MAO. Because we're talking about MAOs, right? For-profit entities.
And the law requires it. Under 42 USC, CFR 41125, it requires an affirmative duty on the part of a carrier to find this
To
information
make
out.
sure I understood, so Mrs. Goldberg's in an accident. She gets x-rays. The x-ray carrier submits the bill to Medicare. Medicare pays. Turns out she has a no-fault carrier. The no-fault carrier is supposed to check Medicare records to see if their insured has submitted any bills to Medicare.
The carrier is supposed to report to the government that insured that beneficiary is insured by them. At the same time that happens, the portal that they report to provides them a basis that this person has benefits and who they're with. What the carrier should do and supposed to do, required by law, is inform Medicare or inform the Medicare Advantage organization. We are primary. Either do not pay because we're supposed to pay first, or if you have paid, we will reimburse you. That is the way the law is set up.
How are they obligated to pay if the insurance contract, and assume with me it says this, the insurance contract says, we are not obligated to pay until A, demand is made, and B, proof is made to us that the accident is related, that the medical expenses claimed are related to insurance.
Under 411.24 subsection F, the Medicare reimbursements do not require a claims filing requirement. They do not require that analysis because they're preempted under 422.108F and further, Judge.
How can federal regulatory law rewrite a contract that's entered into between an insured and an insurer in the state of Florida?
It is not, and the law is that when the legislature enacts laws, they're presumed to know the backdrop of the state laws, and they do, because
you're misunderstanding the hypothetical, and I'm sure that's my fault. I'm not talking about a state law. A contract entered into between an insured and insurer requires two things. A, that before I owe anything, demand must be made, and B, before I pay anything, it must be shown to me by some standard of proof that the claimed expenses are related to an accident for which I now owe money. That is not anything to do with state law, nothing state regulatory, no state regulation, simply a contract between an insured and an insurer.
it actually is, Judge, and here's the reason why. No fault benefits are mandated by statute. 627.733 through 627.736. The contract has to mirror the statute. So the reality is that it is a statute that would control this notice requirement. The PIP carrier cannot put anything in their contract. So this is not where federal law is essentially trumping a contract. Federal law establishes that under 422.108F, if there's any law in the state statutes that conflicts or causes an issue as it pertains to a Medicare Advantage or CMS to recover, it is preempted. That is the ruling in the Real case. That is exactly what the Real panel stated. Now, let's take another step. Here's the other issue, Your Honor. Once, because this case really is about certification, no one here has established that MSPA Claims 1 has won. This is where there's a practice and course of conduct, so we can't lose sight of the fact that this is a certification order.
This is not a merits determination,
right.
It's a certification.
Correct.
So you're trying to hit numerosity, typicality,
Correct.
and so forth.
So,
Now,
but we're looking at, is this gonna break down to a bunch of mini trials? And is it the position of the plaintiffs? Hey, it won't be mini trials because the state law contractual defenses to a PIP claim don't have to be looked at in this context.
Well, first of all, there's no affirmative defenses, so they waived those. So there's nothing in the record. So even if the
What is
court...
the status of the affirmative defense? They moved to add affirmative defense.
But
Was that denied?
The judge said she would not consider them because they were late, so therefore,
So they're denied?
I don't know that she denied it. She said, I'm not going to allow you to raise affirmative defenses because you essentially have a class certification here. I don't know that the defendant cannot come back and try to amend the certification order because certification orders are not set in stone. It could be decertified, but I want to make sure that we follow the...
How
yes.
about this? You're pursuing a claim for a class. By the way, your class is a class of MAOs.
Correct. Or their assignees. Correct.
Are you also trying to create a defendant class?
No.
Okay. So you're asserting a claim for an MAO. We want payment from, and only against this carrier, right?
Correct.
Okay.
Well, this case in particular
So,
is.
and this carrier says, for Mrs. Goldberg, she had this accident, vendors paid, MAO paid, we want to collect from the carrier. Well, her policy limits are $50K. Okay, this would push it to $55K. Is that waived by federal law?
No, but see, we got to go back because I think I want to make sure that we don't lose the factual circumstances of this case. Number one.
Counsel, I want to go back because I'm looking at Real and I'm having a tough time understanding what your assertion is. As I read Real states it relies on, first of all, not the CFR that you've cited, but 42 CFR section 422.108F, which specifically says that rules established under this section supersede any state law, regulations, contract requirements, or other standards that would otherwise apply to MA plans.
Correct.
That's what it says.
Yes, that's the one that I quoted before.
Right.
422.108.
Right. There's no rule or regulation or contract that affects MA plans. The statutes that you've referred to govern PIP contracts, which isn't an MA plan at all.
No, the MA plan is the plaintiff, the
Right,
one
exactly.
seeking reimbursement.
Oh, I'm very aware, counsel.
So what?
I just read to you the statute. The statute supersedes anything that state law or a contract might do to affect the MA plan. That's completely separate from the PIP contract.
But the MA plan gets affected by imposing a heightened scrutiny of how an MAO or CMS can recover.
How has state law affected the MA plan at all? The MA plan can either pay or not pay under its requirements or rules. The only thing that was preempted in Real is subrogation, and because that did affect reimbursement from the MA plan, in other words, how much was ultimately going to be paid to the MA plan. But I'm having a hard time understanding how requirements, either in state law or a contract that impose notice or demand requirements and relatedness requirements somehow are preempted by the very provision that was at issue in Real, which is not the one you just cited to this court.
So two things. Number one, there's still an exhaustion issue because all of these claims arise
So
under
we're
the
putting
Medicare
preemption
Act.
aside right now.
Okay, so I'm going to put
I'm asking, are you putting
preemption.
aside?
No, I'm not putting preemption aside. I'm going to reach you.
Then let's stay on preemption. So tell me how it's preempted.
Okay, so Real stated it wasn't just focused on only the subrogation law. That was the statute at play.
That was the only thing at issue.
But the broader scope of the case is that in Real, the court stated that the broad and express preemption clause in Part C of the Medicare Act was not established by the claim that Real had made. And it said very few exceptions, none of which apply in Real, are available to someone claiming that the 422.108F does not encompass preemption. So what happens is essentially is that there's an established system and protocol for reimbursement claims, which is where the arising under law comes into play.
Right, which makes sense that subrogation, which could affect that, because it affects who gets paid at what particular time and moment. But I'm having a hard time understanding how notice and demand requirements and relatedness requirements, either under Florida statute or the contract itself at issues here, are affected by these very provisions which I just read to you. The reliance that they have, there's only two statutes in the express preemption provision of Real that are cited. There is 42 USC section 139W-26B3 and 42 CFR section 422.108F. And I read to you 42.108F, and it applies to any sections of state law, regulation, contract, or other standards that would otherwise apply to MA plans. And I'm just having a hard time understanding how demand requirements and relatedness requirements affect MA plans.
Because the MA plan is the one seeking the reimbursement. And in essence, a reimbursement is really a subrogation. So what's going on is that the MA plan has made a payment, they're seeking to obtain subrogation. It's really the same thing, Your Honor. It's no different. What happens is...
Well, I understand subrogation, I do, and I think...
Reimbursement is subrogation. It's no different.
I don't disagree, but we're not talking about reimbursement, we're really talking about prerequisites that have to happen before before payment is actually going to be made.
Well,
Yeah, subrogation, usually you have the defenses.
1395 YB3 is a reimbursement statute.
I don't know
YB3
about-
says that you don't pay or properly reimburse,
If
the law is triggered.
If I may, I want to go back to my question,
Sure.
which is, let's say an MA, one of the class members has a bill. They paid. One of the providers said, we provided Mrs. Goldberg with aspirin, $50,000. So you submit that. We
Yes.
want to get paid $50,000. Doesn't the carrier have a right to say, well, that's not really reasonable for a bottle of aspirin?
If they comply with the administrative remedies, absolutely. That was the whole thing in Western Heritage.
But, okay, I guess that's where we headed to the exhaustion
Yes.
thing that you were going to raise, but they are allowed to raise that, yes?
We're not saying they're not allowed to raise it, but they have time limitations to raise that, and it's gotta be
Well,
done.
that's where it looks like it's a mini trial, but let me ask you this. What's your exhaustion argument? Because I'm not really clear on that.
The exhaustion argument is pretty straightforward. It's in the Real case, and it states that any claim for reimbursement arises under the Medicare Act, and you must exhaust your administrative remedies, and then only after that do you have a right to seek judicial review under a very confined federal statute that allows you to go to federal court, none of which the insurance company has done. As a matter of fact,
Let's talk about Real, because in Real, regarding the exhaustion, the very thing that we're talking about right now, isn't Real specific that it's the enrollee that has the appellate rights or the exhaustion rights?
no, and this is the reason why. Well, yes, but let me explain to you why that, yes.
So let's talk about Real first, and then I'll
Okay.
want to follow up. So page 204 of Real. Contrary to what the Reals would have us believe, courts have consistently and overwhelmingly held that disputes concerning reimbursement of conditional payments are claims for benefits that arise under Medicare and must be exhausted through an administrative appeals process before an enrollee invokes judicial review in a federal court.
Correct. And
Who
then,
stands in the shoes of the enrollee here? I know we asked that question before, and I think you said it was you, right?
No.
You're the enrollee.
well, the enrollee is the beneficiary
Right.
that
And you say-
Medicare Advantage.
And you stand in the shoes of that as the assignee.
Right, but when the enrollee, okay, so in
So aren't the
Western,
appellate rights, I guess what I'm asking is, aren't the judicial review rights that they're talking about here, both Real and the regulations, your rights, if you contest it, not the
No.
primary payer's rights to contest?
no, because in Western Heritage, Humana versus Western Heritage, the court, Judge Cook granted summary judgment, and the 11th Circuit U.S. Court of Appeals affirmed and specifically stated, because Real did not exhaust her administrative remedies, Western Heritage cannot contest the claim.
So let's
And
talk
that's the
about-
primary payer,
So let's
Western
talk
Heritage.
about Western Heritage.
Yes.
So looking at that case, page 1240. There, what they said is, before Western settles with the Reals, Humana issued Real an organized determination of $90,000 plus. Miss Real was entitled to administratively appeal that amount, but did not. The amount that Humana may recover is therefore fixed, at least as to Miss Real.
Correct.
But isn't the appeal as to the amount? In other words, it goes to Judge Lowe's question that if for some reason the aspirin is 50,000 and it should be 55 or 50, it's 55 as opposed to 50, that you get to contest the amount. But that doesn't go to preempting defenses under the PIP statute, does it?
No, as a matter of fact, the exhaustion of administrative remedies goes to whether or not treatment is available and whether or not a bill gets paid. And an organization...
I just read to you what they're talking about there. They're simply talking about the amount.
Well, the issue there was that Western Heritage was contesting that even if they were liable, they still had a right to contest the amount because there still remained a genuine issue of material fact. The court goes through that analysis and states, you cannot contest the amount.
But it doesn't say anything about obligations to owe, whether it owes.
But every single case under the arising under analysis deals with benefits that could be provided as well as amounts. So we're not saying that they don't have a right to contest this.
So
we're just saying that they're not in the proper forum to contest
how
it
do
because...
How do we get around Medicare? How do we get around Real's statement about the same thing you're talking about, that it's the enrollee that has the requirement there?
But Real is looking at the enrollee, whether or not the enrollee was contesting the amount. And ultimately, the 11th Circuit U.S. Court of Appeals said it doesn't matter if it's the enrollee. Western Heritage fits into the analysis of the enrollee because
so
you can't...
Your court's sort of combining cases here. Real specifically dealt with the enrollee's right. And it specifically said that the right was the enrollee's. Didn't extend it anywhere. In Western Heritage, they simply said it was limited to amount. It doesn't say anything about notice or relatedness or any of the other potential defenses that are out there.
All the cases cited by Real are all cases in which an enrollee and even primary payers have sought to contest the amount and coverage, and all of the case law states that you must exhaust administrative remedies.
Let's look at
Who must?
Let's look at
Who must?
The enrollee, an
primary
assignee of the
payer?
enrollee, or the primary payer.
You say that I know the order says that, but let me go back to, you just said the cases relied on in Real. Let's go through all of them. Collins versus Wellcare, 73 Fed Sup 3rd 638. The holding, and this is quoting from the holding that a Medicare Advantage enrollee's state court action seeking a declaration that an MIO was not entitled to reimbursement was arising under. And Einhorn versus Care Plus Healthcare Plans, holding that a Medicare's enrollee's Florida Consumer Protections Act claim. Cup versus Johns, holding that a Medicare Advantage enrollee's Arkansas subrogation law action. Potts, holding that a Medicare Advantage enrollee's action seeking declaratory judgment. Phillips versus Kaiser, holding that a Medicare enrollee's California consumer protection claim. I don't see anywhere where it deals with the primary plan.
The enrollee, well, first, Humana versus Western Heritage does squarely deal with primary
But it
plans.
dealt with amount, only amount.
I don't think the holding limits it to just the amount.
I
It
just read
talks about administrative remedies.
I'll just read to you. This is from footnote 11, or from headnote 11 of the opinion. Western Heritage. Before Western settled with Real's, Humana issued Miss Real an organizational determination of $19,000. Miss Real was entitled to administrative appeal that amount, but did not, citing a reg. And then that the amount that Humana may recover is therefore fixed. That's it.
Every claim by an enrollee against their Medicare Advantage organization or the government, CMS, involves whether or not they're able to seek treatment as well as the amount. So it encompasses all of it. Now, yes, we're looking at Real and we're looking at Humana versus Western Heritage and we're fine-tuning that it states because of the amount. That's the argument that was being addressed at that point in time. Here's the other issue. The PIP carrier indemnifies the enrollee. So if the PIP carrier indemnifies the enrollee and the enrollee has already been paid, in essence, because Medicare has paid those benefits, it's the same thing. The PIP carrier steps into the shoes of the enrollee for those arguments, just like in the Western Heritage case, because ultimately speaking, the amount paid on behalf of that Medicare beneficiary is already set in stone in terms of the amounts that have been paid and a determination of the physical and mental condition. I'm not really disagreeing with what this panel is asking me about. All I'm saying is, yes, those may be available, but they have to be administratively exhausted. And here's the reason why the certification should be affirmed. Because there's a practice and course of conduct that this insurance company did not exhaust administrative remedy. So here's how the case plays out. Primary payer, they're the insurer. By the way, I wanted to make note that we did give them notice. So they did have notice, not only for the individual claims that were presented at the certification hearing, but in addition to that, in April of 2016, we sent a letter under 41125 specifically stating.
So you agree that you have to give note, that an MAO has to give notice of the claims?
I do not agree that they have to give notice, but we gave it anyway. So even if they did have to give notice, we complied with it.
Of course, obviously, you know, because it's a class action, we're
Right.
talking about the claims of the absent people.
And we did that, Your Honor. Under 41125, we sent a letter in April of 2016 stating before the certification, tell us every single insured that you insure that's also a Medicare beneficiary, and give us the name, how much you have in available coverage limits. Silence. Never got a response to it.
Okay, I would have thought a claims letter would be, here are situations where we, the MAO, have paid, and these people are insured by your company. This is within the policy limits. This is reasonable and related. Pay us this amount. It sounds to me like yours was almost a discovery letter rather than a claim letter.
Because
When you write a claim letter, Mr. Ruiz, it's like, pay me 1.5.
yes, but if we read Baxter and all of the cases that follow Baxter, it basically states when Medicare pays, they're paying in the dark. They don't know what's going on. So the whole system is set up so that Medicare does not have to go through this onerous process and burdensome process to establish that their Medicare beneficiary had all these things happen. Because let's face it, then it's just basically catch me if you can, which is what's happening in the industry. It's catch me if you can. So the system is set
A
up.
couple penalties are there, I guess, is when we catch you though, it's gonna be a little
But
sanction.
what if somebody doesn't sue under 1395 YB3? The double penalty is just that statutory
I find it
basis.
very hard to believe, even with Medicare itself, the federal government itself, that they can say, we paid, and without an insurance company being on any notice, and regardless of what their contract is with the insured, that the insurance company has to pay. I mean, actually, that doesn't, if you think about it, that makes no sense.
I agree with you, but that's what the system is.
Wait a minute, that policy's expired, that's preempted, you know, policy limits were exceeded, that's preempted. This goofy Medicare, you screwballs, you did it again, you paid $50,000 for a bottle of medicine, that's not reasonable, right? I mean,
And
are
that's
you
still
saying
available.
all of those are preempted?
No, what I'm saying is that when they are preempted, they're preempted. If they're not preempted, then there's an administrative process that they have to go through.
Okay, but let's say, so Medicare says to the insurance company, we paid $50,000 for a bottle of insurance, for a bottle of aspirin. If it was related to an accident, no fault, pay us $50,000. So you're saying at that point, now the company's on notice, then they go through an administrative procedure.
Correct?
Okay. So with these folks, when the class gives them notice to this particular carrier, can they then instigate the administrative procedure?
Well, that's the reason why the case was certified, because
Exactly.
whether or not
Exactly.
one of the issues is whether or not they've administratively exhausted, and if they have, it's class-wide. And if they
Wait a
can,
minute, stop that.
yes.
Why would you say class wide? What if they exhaust administrative remedies in one claim, but not for Mrs. Goldberg's claim?
Then what happens is, first of all, there's a
Just-
60-day
Then
requirement.
they have to pay the $50K for the bottle.
There's an administrative time requirement, it's 60 days. Those days came and
60
went.
days from notice, or
Yeah.
60 days from what?
60 days. It's 60 days from an organization determination, and an organization determination occurs when payment is made.
And speaking
By
of
made payments by
administrative time requirements, we've given you a lot of extra time.
Okay.
Questions, 2 minutes.
I just want to leave the panel with the following so that you understand, because as we all know, the Medicare Act has been labeled as the most complex law that exists.
Indeed,
Now,
I'll agree on
here's the way that it works, so that the panel leaves on an understanding. We are not saying that some of these issues that the panel has raised are set in stone and that there can be no defenses. But there were no affirmative defenses raised, so the record is devoid of any affirmative defenses. The record is devoid of even the adjuster who stated all of these claims are paid and they're all determined to be reasonable, related, and necessary. You need to go back and look at that, because you can't just raise a defense with no evidence behind it. So there's no evidence in the record here that any of those questions, Judge Lowe, that you asked me exist, because what they do is that they get the claims and they pay them, right? So they paid the claims that they were sent. We gave them notice that they had other claims. They never did anything about it. They never reported it to the government. So there's none of these claims have been reported. They have a very faulty system. That's the practice and course of conduct of what is going on with this insurance company. Ultimately stated is, yes, those things can occur, but they don't affect class certification.
Did you allege, Your Honor, and you raised a couple of interesting points there, because obviously, the whole purpose is the primary payer is supposed to pay.
Correct.
So, but did you allege, hey, this company was on notice that, Mrs. Goldberg had the accident and there was,
Yes.
and this company was sent a bill by the pharmacy saying, we want $50,000 for the bottle of aspirin. And what they do is they just sit on it, figuring, let's see if Medicare pays.
We allege that at a minimum, they had constructive knowledge and that it was their burden, their onus, to report to the government their primary payer responsibility under 411.25. So the answer is yes. So we gave them all the notices that they needed, that they were responsible for these payments. They just decided to not do anything.
They must be on, so they were on notice that Medicare pay, or the MAO,
we
paid
gave them
$50,000 for the aspirin bottle. That's part of your, in other words, that's part of your, you would have to prove that.
We have to prove, as the plaintiff, that there's a primary payer, that they should have paid, or that they failed to reimburse. And damages. If you get into the reimbursement, I think Judge Lux simply set the elements that are necessary for this case. Those are the three elements. And everything else is either preempted.
Yeah, but they're huge to me. Of course, it goes to the discussion you and Judge Lux had.
But you
There seems
understand
to be huge, there seems to be a lot of issues. Do you have to reimburse? Well, you have to be on notice. It has to be, related to the car accident. It still has to be,
these are things that get done in class-wide proof. Medical bills are paid every day in this country, and they go by ICD-9 codes, ICD-10 codes, and CPT codes. They're almost self-authenticating. If you have an ICD-9 code, and we showed that at the certification hearing, if you have an ICD-9 code,
who has the ICD-9 code? Medicare or the carrier?
They both do. That's how claims get paid. So when you have an ICD-9 code, it's basically an international code of diagnosis. It says if you have a headache, you go to the doctor, you say, doctor, I have a headache.
It's related to a car accident.
It's related to the car accident. And the ones that we showed even had an E code. It's called an external cause of injury. It showed that it was a car accident. On the proof, the claims themselves. So I want to make sure the panel doesn't leave here thinking that this is one bill at a time. This is all electronic data. This is how Medicare processes millions and millions and millions and pays off billions of dollars by electronic data. We established by competent, substantial evidence in the record that there's a methodology, that there is a practice and course of conduct, and whether or not there are some of these issues, they are not the issues that predominate over the litigation. The issues that predominate over the litigation, it's not about being right or wrong right now. It's about whether or not
And
there's...
the relief you seek is?
The relief we seek is that if a carrier like Ocean Harbor has noticed, constructive or otherwise, that they are primarily responsible, it is their burden to make sure that they notify Medicare and that they pay the way that they're supposed to pay so that Medicare doesn't get stuck with the bill. Because if you do it any other way, Your Honor, it basically turns the entire system on its head, and we wouldn't be here because we would be doing nothing other than arguing about a PIP case.
Thank you very much.
Thank you. And I ask the court to affirm and thank you for the extra time.